If an officer is making a demand based on a suspicion for a roadside breathalyzer sample, the officer has to meet several preconditions. If an officer has a reasonable suspicion of alcohol in a person's body at the time that they operated a motor vehicle, then they may make a sample demand for a roadside breathalyzer. The reasonable suspicion component requires the officer's suspicion to be reasonable. This means not only must the officer subjectively believe that there's alcohol in a person's body, the officer must also have an objectively reasonable basis for that suspicion. In Canadian law, the reasonable basis for a suspicion of alcohol in the body is generally recognized that if you have an odor of liquor on your breath, or if you've admitted to recent consumption of alcohol, either of those two things can ground a reasonable suspicion that there's alcohol in a person's body. However, the inquiry into whether or not there's a reasonable suspicion is not absolute. It's always based on all of the facts known to the officer at the time or that reasonably were available to the officer based on the information that he had. In those circumstances, this means that in some cases, a basis for a suspicion that was reasonable in another case might not be reasonable in one case, and vice versa. In some circumstances, an odor of liquor in the vehicle alone has been found to be sufficient to ground a reasonable suspicion, whereas in others, the courts have determined that that is not a sufficient basis for a suspicion demand. The officer also must believe that the alcohol continues to be present in the person's body. And this makes sense, because if there's no alcohol in your body, why are they asking you to provide a sample into a roadside breathalyzer? And so the officer has to have some basis not just to believe that the alcohol was in your body at the time that you were operating the motor vehicle, but also that the alcohol continues to be present in your body. There's also a requirement that these demands are made within reasonable proximity to when you were operating the motor vehicle. So the police can't just come to your house or can't just pull you over and then wait hours and hours and hours to demand the sample. The sample has to be demanded within 3 hours after the time that you ceased operating the motor vehicle. This prevents too much delay from occurring between driving and when the sample is obtained to actually relate those two things to one another.